Good afternoon, everyone, and welcome to RIG Global's webinar on ASB Powers. I think we all agree that incidents of antisocial behaviour were increasing for a number of years prior to the COVID-19 pandemic. It's unclear really whether that was due to irresponsible behaviour by individuals and people not caring about the impact their behaviour had on other people, or whether it was down to society in general being less tolerant about not things that impacted on them. My name is Huw Williams. I work with RIG Global. We've got a full agenda for today. We've got three excellent speakers who are going to talk about antisocial behaviours and the powers. Just want to give you a bit of an introduction to the webinar this afternoon. We did a bit of research using information from the Noise app, which the company supplies during the beginning of the lockdown, and this highlighted that antisocial behaviour was increasing considerably during that period. I think it's due to quite a range of different problems. If you can put the first slide up, John, that would be helpful. Thanks. There was issues clearly around people being isolated, living in properties and experiencing noise problems that they may not normally be familiar with. They clearly had concerns about financial issues, employment, home working, and I suspect many people ringing in today or dialing in today to the event will be doing it at home. So people's life experiences are changing considerably with lockdown and the pressures that come with the pandemic. We've got issues around homeschooling of children and stuff like this. So what happened, I think, was there were clearly pressures both sides of the party wall. People who were getting wound up and irritated. And in some cases, one person's way of relaxing and dealing with the pressures was a wind up for other people living the other side of the wall. So I think we need to be aware of that. But we have seen significant increases in antisocial behaviour. It has presented challenges for enforcement agencies in deciding whether noise and behavioural issues are reasonable or unreasonable, because there will be things that people are hearing and encountering which are not unreasonable and don't require enforcement action to be taken. In dealing with all these issues then, it's about selection of the appropriate remedial intervention and remedial actions, and deciding what ones you should select is going to be covered hopefully in brief this afternoon. Move on then, John. Thanks. I think there's issues here about who is the victim, because in a lot of circumstances now, the victim could be the person on the receiving end of the problem, but there are also issues now around mental health capacity, illness, and other aspects. And so the person who's creating the problem could themselves be a victim. We're going to look at the caseloads of officers clearly need to be focused on, because when officers are busy, they've got to make decisions about what's the priority, where they need to be spending and focusing their time, and also which interventions they should be selecting that can have the greatest impact and the quickest impact in dealing with the issues. Harm is something we could be covering today as well, because I think there needs to be a focus on the harm arising and associated with antisocial behaviour. There's also issues now around mental health. Clearly, we've seen during the period of austerity, some critical and important services suffering with cutbacks and not being able to provide support to individuals and to services in the way that they may have previously. And this again creates a burden and a problem. Mental health is clearly a factor. We're seeing more of this, and one of the speakers, Tim Everett, this afternoon will be focusing on some case studies in relation to this. The programme for this afternoon, it's been circulated. We'll now bring it up on the screen. We'll highlight the three speakers that we got doing the presentations this afternoon. Janine Green is an expert in antisocial behaviour matters. Many of you will be familiar with Janine's work and may well have attended events that she's participated previously. Janine is going to concentrate on harm-centred approach to ASB issues. And we're very pleased also to have Tim Everett with us this afternoon. Tim's ex-president of the Chartered Institute of Environmental Health. Tim is going to pick up and cover issues, some case studies in relation to enforcement action and mental health. And I'm pleased also that we've got Marriner joining us. He's the Chief Editor for RIAMS, which is the library that we've got at RIG Global, which documents policies and procedures, and Ian's going to cover issues around ASB tools for nuisance cases, because I think it's still a strong argument that it's almost like a twin track approach is needed in some cases, where we need to look at stat nuisance, but we also need to consider whether it's appropriate also to include and utilise ASB interventions. If I can hand over to Janine and to start with, once the speakers have done their presentations, we may have some time for some questions and answers at the end, but I don't want to constrain the speakers with time. They've got a lot to cover, so if we kick off with Janine, hope you enjoy the event.
Thank you very much. Thank you for that introduction, Huw. I should say I wasn't being shy by hiding with my camera off. I've got a number of people in my household at the moment that are using the internet, and I'm really conscious of delays and freezing. So I am here. I'm not going to hide away for the whole session, but I'm just conscious of making sure it flows as much as we possibly can do today. So as Huw says, my name is Janine Green. I've worked in ASB for, probably about 15, 16 years ago. Now I have worked in housing associations, I have managed local authority ASB units, I have been managing director of a national membership-based organisation, and about 2 years ago I made the decision, crazy or clever, I don't know, to go self-employed, and have been doing that for the last 2 years. So I predominantly work with local authorities, police forces, housing associations, to help them in a variety of ways in terms of tackling ASB and dealing with other community safety issues. I'm also really pleased to be the kind of moderator for the community's ASB forum, and hopefully one of the things that you'll take away today is joining me on that forum, which gives you the opportunity to ask questions, share documents, seek advice, etc. So hopefully some of you are using that already, but if not, you certainly will do after today's session. So I was really grateful to RIG Global, because when they approached me and asked whether I wanted to speak on this webinar, they said the magic words, which was, you can speak about whatever you want, which to me as a speaker is a joy, because I think sometimes, you know, I get asked to do lots of webinars, lots of kind of public speaking events, and usually there's very clear and firm parameters around those sessions, and very often I might be asked to talk about the tools and powers, or I might be asked to talk about, I don't know, possession grounds. So it was really nice to have a little bit of flexibility to pick something that is, I think, particularly kind of pertinent and topical at the moment. And so for me, particularly going through a pandemic and some of the things that Huw's touched upon in his introduction, it was a kind of no-brainer really to aim this session around what we're commonly calling at the moment a harm-centred approach. And I guess the reason why I wanted to cover this topic was, I think we're hearing it. It's a bit of a buzzword at the moment in ASB and community safety. And I just wanted to unpick it a little bit and make sure that we all understood what we mean by a harm-centred approach, but also why we want to adopt that kind of approach. And I guess most importantly is, how do we embed it in the work that we do? I'm always very happy to speak at these events. I give my time freely because I think it's very important to share knowledge. But for me, it's so important that people have practical things that they can take away to really change practice. And what I hope you're going to get from my session a little bit is perhaps just starting to think about some of the ways that you might embed some of this, or perhaps you already do it a little bit, but it will give you some thoughts around some other ways. So I have a glamorous assistant today. Jonathan is working my slides, which is fantastic. So Jonathan, if I can ask you to flick through to the next one, I'd be very grateful. So I don't know how well you can see this, but I will describe to you what you can see on the right-hand side of this slide. And to be honest with you, it doesn't really matter if you can see it or not, because it was a waste of time and a waste of space in reality. It is a table that, if you've worked in ASB for any longer than maybe 6 or 7 or 8 years, you will have seen this table everywhere. It was kind of the typology of ASB and listed all the different types of ASB, and people kind of cut and paste it into ASB strategies, and you might have seen it in policies and you might have seen it in procedures. So the old approach to categorising ASB was very much about creating an absolute list of what was ASB and what wasn't ASB. And while there was a little caveat at the top of this table that said this is not an exhaustive list, as human beings, we like rules and we like parameters. So we kind of grabbed onto this table and we're like, fantastic, it's a bit of a checklist. If your behaviour comes under this list, then it is ASB. If you're reporting something that isn't on this list, then it isn't ASB. And I think we kind of anchored ourselves to that and thought, fantastic. The problem with it was that, again, as I said, it listed things very black and white, but also it didn't look at behaviours from the point of view of the impact that that behaviour was having. So there was no kind of severity rating, there was no kind of which things are a priority. They were all just seen in the same way, which was these are the things that are ASB. And there was also, I think, very much kind of 10 years ago, this kind of view that every intervention had to be the same for the same behaviour type. So again, I used to see policies and procedures that would say, well, for noise nuisance, we'll always issue a warning letter, or, you know, we have to treat similar cases with the same behaviours in the same way. It's equitable, it's fair, that's what we have to do. Fortunately, we've moved on a little bit from that kind of black and white approach. And if Jonathan can move on to the next slide for me. So when we talk about harm-centred approach, what we're doing is first and foremost actually fully appreciating that the definition of ASB is subjective. And the one challenge of many challenges that exist for ASB practitioners is that there are a multitude of ASB definitions. So even if you look at the ASB Crime and Policing Act of 2014, every tool in that toolkit has a different definition of what constitutes ASB or nuisance. So it's actually quite difficult sometimes to define ASB. I think sometimes we go back to the crime and disorder definition of behaviour causing or likely to cause harassment, alarm or distress. But actually, if we're working in a housing related field, that's a higher definition than what we should be working to as nuisance and annoyance. So it is quite a challenge in terms of those varying definitions. But the one common factor across them all is they're based on how it makes somebody feel. They're not based on acts, on behaviours. They're based on the impact that it has on the person that the behaviour is being caused to. Huw picked on it really well at the beginning of his session. Different people respond to things in different ways. There are a huge range of factors that's going to affect that. Things like age, our health. You know, we commonly know now that things like whether we're isolated, so whether we live alone or whether we've got friends and family around us, makes a big difference in terms of the impact that the behaviour that's being caused to us is having. And we've really seen that playing out at the moment in terms of going through the pandemic. And, you know, when we planned this webinar, we had absolutely no idea that we'd be 48 hours away from another national lockdown. I mean, let's be honest, Friday night, I still had no idea that we'd be going into a national lockdown. So we are at the moment, again, in a period of really heightened anxiety. I'm feeling it, and I'm sure that everybody else, you know, who's listening in is feeling it in some ways. Overwhelm, anxiety, fear, you know, and I'm really lucky, I'm still working. So I haven't got the financial issues that other people might be having as well. All of those things are going to really heavily impact how resilient we are, how well able we are to deal with ASB. And again, therefore, when we're deciding how serious something is, we've got to think about the impact as well as the behaviour type alone. And that's what that next point on my slide is saying. When you are getting reports of ASB, when you are deciding what the proportionate response to that behaviour should be, when you're deciding how much priority to place on it, it is so, so important to think about the circumstances and not just the behaviour. And I think it's really about embedding this approach throughout the casework. And if Jonathan can just move on to my next slide, I want to talk a little bit about why is this so important? And again, on the right-hand side of my slide, there's an image which I'm sure, unfortunately, most of the people watching this webinar have seen on many occasions. And I'm sure that 99% of you, if not 100%, will know that that's Fiona Pilkington and her daughter. And I think sometimes people think, well, why are we still talking about something that happened over a decade ago? And for me, there's two reasons. Firstly, the huge impact it had on the way we tackle ASB, rightly so. But secondly, the fact that I still don't feel confident that we're in a position where a situation like this wouldn't happen again. And through all the work that the government have done around changing the legislation and through introducing the community trigger, I still don't feel comfortable saying we've got it right and this kind of situation would never happen again. For those of you who don't know, Fiona Pilkington and her daughter, who were in the picture, both had learning difficulties, were experiencing some quite significant antisocial behaviour, got to the point where they couldn't take it anymore. Fiona ended up taking her own life and that of her daughters as well. Serious case review, as you would expect from such a tragic set of circumstances. And some things were pulled out around the fact that the risk hadn't properly been identified. You know, the alarm bells were ringing all over the place. There was learning difficulties, there was isolation, there was lack of support. All of those factors that we know make somebody more vulnerable were present, but the agencies didn't join the dots together. Each agency had a piece of the puzzle, but what they didn't do is bring those puzzles pieces together. So they were taking and deciding on action based on a tiny piece of information rather than the whole jigsaw puzzle, the whole situation. So, of course, the reason why we want to adopt a harm-centred approach is to stop, to try and prevent something like this from happening again. Of course it is. But there are other reasons why we do it as well. Some of those are business. And I almost feel a bit icky sometimes when I talk about business when there's such, you know, a kind of person affected. But it's really important that we do talk about business risks. And of course, if we have a serious situation like this, then it creates a huge reputational issue for us. You know, I know that the people that were involved in the Fiona Pilkington case still feel like they have a bit of a black cloud over them now. So it's really important from a business point of view that we are managing these cases properly from a personal point of view, but also making sure that we are targeting our resources appropriately, that we are prioritising the right cases, that we are using our limited amounts of money to tackle those cases where we've got people most in need. So how can we do it? Jonathan, again, if you could just move through to my next slide. So how do we adopt a harm-centred approach? And so this to me is the most important slide from my session, because this is the things that can make a difference to practice and help support people who might be vulnerable. So the first thing I would say is make sure that you have a harm-centred approach embedded in your ASB policy. ASB policies for me are massively important. We talk about them sometimes from the perspective of them being something to wrap people over the knuckles with. So you go to court for an injunction or possession and you haven't done what your policy says, and the defence team is going to attack you on that, and that's how they're going to try and win the case. So because of that perception, we kind of think about an ASB policy as being something that is a bit of a problem for us. But actually, if we can get a well-drafted ASB policy, there are huge amounts of benefits as well, because it helps bring consistency to our practice. It helps manage expectations of our partners, of residents, of councillors, of MPs. It helps us manage those expectations. It helps to justify our decisions. You know, should there ever be service complaints or ombudsman inquiries or community trigger reviews, it helps justify decisions. So please make sure that your policy is consistent, is clear, and is a good policy. And as I said, if you can embed your harm-centred approach into that, it's a great start in kind of ensuring consistency. The other thing that I would say is, please, as an officer, when you're kind of using your professional judgment to decide how serious a case is, please don't necessarily judge it on how you would respond to that behaviour. Remember, the test is subjective. How you would respond is sometimes useful as a kind of gauge of whether it's something that's unreasonable or not, but you've got to be putting yourself in the shoes of somebody who is going through those things in the circumstances that they're in. And I have to say, this really came to the fore for me in lockdown, because I live in a terrace property, and my next door neighbours were going through home renovations for the start of lockdown. So I was incredibly stressed out anyway. day, incredibly anxious and trying to work from home. And suddenly I could really feel and understand how much impact something like noise nuisance can have on people. So it really brought it home to me that we have to try and understand and put ourselves in those people's shoes. I think a good policy, while I do think it should give a list of types of behaviours that we will consider as ASB and types of behaviours that are unlikely to be ASB, because that helps manage expectation, it really needs to make clear that it will be judged on a case-by-case basis, and that those other factors will be used to help decide, one, whether it is defined as ASB in the first place, and two, how much priority is going to be placed on that. I know lots of organisations will have different categories of risk. So you might have high level ASB, which is your threats of violence, actual violence. You might have more general categories of ASB that, you know, the response for high level might be 1 to 2 working days. The response for more general might be 5 working days. What I don't see so much of is in that higher end category, psychological harm being recognised. And interestingly, you know, the injunction, things like the without notice injunction, says that you can get a without notice injunction if there is a genuine risk of serious psychological harm. So I think sometimes we forget that and always think it's about physical acts of violence, etc. So I always encourage organisations to include, when they talk about categories of serious ASB, to include and think about psychological harm as well in that. Hopefully most of you will be doing risk assessments for complainants of ASB. So I would imagine most of you are doing that. What I would encourage you to think about is whether they are serving the right purpose. So I still see risk assessments that are completed almost as a tick box exercise and then never reflected on again. And what I would say, and again, what has really come to the fore through these recent months, is that vulnerability doesn't stay static, it ebbs and it flows. And if you think about somebody's vulnerability levels through something like a global pandemic, it is going to be going like this. So it's really important, whether it's through your case review processes, your supervision processes, that those risk assessments are kept under review. The Fiona Pilkinson case was a massive reminder of the fact that we have to work in partnership, that we are unlikely to know the full facts related to a case. And it's only when we know the full facts that we can decide the best course of action to take. So please make sure that we are getting involved in those partnership forums, that if we've got a case where we've got people who are vulnerable, that we are linking into the forums in our area and making sure that wraparound support is in place. And that's not just for the victims, that's also for the perpetrators. And I think that for me is a really important point as well, because I think sometimes we get so caught up in things like the Equalities Act and making sure that we show the courts that we've supported the perpetrator or offered the support to the perpetrator, that we inadvertently forget the victim. And when we're looking at it from a scales point of view, we're offering far more support to the perpetrator than we are to the victim. So I would just say, please don't forget about the victim and the fact that the victim might need support as well. And I think the final thing for me to say is, if you're doing all this great work around recognising harm, and if you're going to court on cases that on paper might not seem that serious, but the reason why you're taking the action is because the impact of the behaviour, is making sure that you are absolutely clear in your witness statements about why you're doing that, so that you're really reflecting the harm on the paper, so the judge can sit there and go, is it proportionate to make this order? Absolutely, I can see from the witness statements, I can see from the proportionality assessments that have been completed that there is a need to grant this order because of the impact that it's been having. So, Jonathan, if you could skip to my next slide, please. Hopefully that's given you, incredibly quick, but I'm so conscious of time and the fact that I can talk for ages. But hopefully what that's done is giving you a little bit of a reminder about what we mean by a harm-centred approach. And as I said, some ways that you can think about starting to ensure that you include that kind of approach into your casework and in your policies and your processes. Final slide, I've just included some ways in which you can keep in touch with me. I do lots of blogging, podcasts, etc. If you'd like to join my mailing list and get hold of some of those, then the best thing to do is go to my website and a pop-up box will appear which will allow you to input your contact details. And as I said, also the moderator for the RIAMS ASB community. So please, by all means, join us and ask any questions and share any thoughts or best practice. And I think that's me, Huw. So back over to you.
Thanks, Janine. Oh, that's great. I think a couple of things to take away from there is the issue around the need for officers to be familiar with the different definitions of ASB. Because in the guidance there are distinct differences between them. An issue as well about going back and visiting policy to make sure that they are consistent, they are up to date, and they do take account of the harm-centered approach. I think that's important. If we can pass over to Tim now. Tim's going to take us through some important case law and issues around mental health as well. Tim's an environmental health officer, ex-president of the Chartered Institute, spends an awful lot of his time now on the legal side of things. So Tim, I can hand over to you. Thank you.
Thanks, Huw. Right, Janine reminded me that one of the most challenging roles I ever had in my career was, for several years, I sat on the county-wide serious cases review panel, which meant unfortunately I had to look at a number of cases of where people had died or been seriously injured in not dissimilar circumstances to the ones she described. People also remember, those of you who are members of the Chartered Institute will remember that for the 3 years my presidency, promoting public mental health issues was one of my key themes. It's an issue I've been interested in for some time. John, can I move on to the first slide, please? Right, so even before COVID, and maybe a lot of wider issues around mental health effects of COVID knockdowns, mental health issues are part of our lives, probably far more widespread than many people realise. About 50% of the population will be affected by a mental health issue during their lifetimes. About 14% of the population will attempt suicide or self-harm during their lifetimes. And in any 1 week, about 1 in 6 will be reporting symptoms of mental illness. So it's a very large chunk of the population. Those are figures drawn from people like Mind, ONS, and very specifically a 5-yearly survey that's carried out, which goes into detail and picks up medical information from across the country. So unsurprisingly, if your job involves dealing with behaviour that's causing problems, inevitably you are going to be dealing with people who have mental illness as part of their framework, and as a consequence, you're going to have to sort of know how to deal with that, both in terms of the practicalities, but also in terms of the law. Mental illness, and I'll come back to it in a moment, mental illness can often be a disability for the purposes of the Equality Act 2010, and that has a number of implications. So both in terms of the way you investigate complaints, but also if you're the decision maker deciding on what notice to serve, whether to prosecute, go for an injunction, whatever, you are going to have to take certain things into account when you sort of apply that sort of that legislation. Next slide, please, John. Okay, 2 key bits of legislation. The Human Rights Act 1998, this incorporated the European Convention on Human Rights directly into UK legislation. Article 8 is the right to private and family life. Article 1 of the first protocol relates to the right to peaceful enjoyment of possessions. Now, of course, they apply to everybody, but they apply to people who have mental health problems as well. And Article 14 very specifically makes it a requirement on public authorities to make sure there is no discrimination on such grounds when considering people's access and possession of those rights. So it brings that into play. Now, for this particular piece of legislation, there is a sort of get out of jail card in some cases, and that's section 6.2. Essentially where the council has to take action, where's a duty under primary legislation, it actually says that, then if the council has to act in a particular way which might be held to be discriminatory, that is generally not going to be a breach. Okay, we then move on to the Equality Act 2010, which is sort of, more far-reaching in many ways. Now, Section 6 tells you what a disability is, and mental illness can be a disability as long as it's more than trivial and affects that person's normal way of doing things, and as long as it lasts for 12 months or more, then it's going to be likely to be a disability for the purposes of this legislation. Under Section 15, it's unlawful discrimination if someone is treated unfavourably due to a disability, unless the council, the public agency, can show that it's a proportionate means of achieving a legitimate aim. And serving a notice and taking legal action against someone, understandably, and the courts have said this, is unfavourable treatment. Well, it is, isn't it? I mean, nobody likes getting a formal sort of notice or a summons. Okay, so under Section 29, in carrying out public functions or delivering public services, public agencies must not discriminate against a person due to their protected characteristics such as disability, and they must make reasonable adjustments. So that's going to raise questions about how you do certain things. A very simple example is serving a notice on a blind person may actually require you to do sort of different things to make sure they understand what they've been told to do or not do. Okay. Under Section 149, the public agencies, including councils, have a public sector equality duty, and that applies to all the functions. And it includes various things. It includes the aims of eliminating discrimination and fostering good relations between those with a disability and those without. Now, we all know that many complaints about nuisance antisocial behaviour, at least in part, rely on two differing lifestyles, which may both seem reasonable to the people in question, but don't work together. So the actual relationship, if it's based on one of those issues, may well prompt the public sector equality duty. Next slide, please, John. Okay, earlier this year, the High Court dealt with in many ways, a very important case which touches on some of the things we've been talking about. This was actually about statutory nuisance, but the issues sort of apply to other forms of action against sort of behaviour. Now, Miss Fisher was a private tenant. She had developed a post-retirement a neurological condition that meant she had frequent involuntary movements, screamed and shouted, often obscenities, and often in the middle of the night, disturbing people around her. And no arguments on either side that her behaviour clearly was causing a very considerable disruption and impact on the neighbours. She'd already been evicted from one private sector property and had been sectioned under the Mental Health Act because of her condition. Subsequently, she moved into another private rented property, and again caused considerable nuisance to some of her neighbours, leading to people moving out. It was that bad, it really was intolerable. So in January of 2018, Durham County Council issued a community protection warning and liaised with her consultants and the relevant council specialist teams to try and find a solution. They put a lot of effort in to try and find a way of engaging with her and getting her, well, importantly, to engage with those agencies, which she frankly would not do. But by November, after further warnings, and because there was a substantial continuing noise nuisance, Durham County Council served an abatement notice on Mrs. Fisher, and she promptly appealed to the Magistrates Court, but she also started judicial review proceedings based on the 4 grounds I've listed here, which is unlawful discrimination because of her disability, breach of her human rights, breach of the public sector equality duty, and serving a notice. She was claiming that serving a notice at all was perverse and irrational, and because she couldn't help her condition. And there's no argument, she didn't do it as out of choice. It was something which happened because of her condition. Next slide, please. Okay, what the High Court held was that yes, of course, the service for abatement notice counted as discriminatory treatment, no unfavourable treatment, no question about that. But in the circumstances, it was proportionate and necessary to achieve the legitimate aim. And the legitimate aim in this case was the duty to protect others from harm. despite her definite disability, they had to take action to protect others. Now, they hadn't carried out a specific PSED. I mean, there's no question about that. But however, the detail they'd gone into in investigating the case, liaising with all the agencies I've mentioned, trying to engage with her, they did all the things you would have expected them to do had they carried out such an assessment. So on that basis, the court said, just because you haven't got a piece of paper which is headed sort of public sector equality duty assessment, doesn't matter as long as you've done the right things. That was helpful. And again, the service of the abatement notice was not a breach of the Articles 8 and 14 on human rights or the Human Rights Act, as the council, again, the council was proportionate in pursuit of a legitimate aim, and they were under duty to act, because no one was arguing but that there was a continuing noise nuisance. That wasn't the issue. Okay, so on that basis, the High Court application for judicial review was therefore dismissed. And the matter returned to the Magistrates Court to deal with the outstanding appeal. Now, one of the points I should add at this stage is that the council realised that they weren't going to prosecute her for non-compliance with the abatement notice, because those of you who know the legislation will know there's a tag of without reasonable excuse, and there's already been case law which says that where you can't help yourself, that will be a reasonable excuse. What they were doing was looking to sort of apply for an injunction, and to do that they had to serve the abatement notice first, and the idea was to ensure that she was moved to more suitable accommodation where the nuisance didn't affect people, accepting that her behaviour was not going to improve, and it was causing a substantial harm to her neighbours. Okay, move on to the next slide, please. So the key points to take away from this is, when you're taking any action against someone which will interfere with their stated human rights, you have to be able to justify this. When they have a disability, and this applies to other protected characteristics as well, taking any related formal action, I say related and I've underlined it, or made it and put it in bold, because as in the Fisher case, she couldn't help herself with her behaviour, so the disability directly impacted upon the use of the powers. Just because someone's disabled, maybe having mobility problems, doesn't mean they can scream and shout. I mean, you get the point. The disability's got to be related to the intervention in question. You will need to show that the action is proportionate and is necessary to achieve a legitimate aim, and that you've considered the options. Whether or not you carry out a formal PSED assessment, you'll need to show, and you'll need to have the evidence in writing, that you've considered all the relevant matters, you've taken the necessary steps before you've taken the action. Very difficult to do it after the event. It may be important to do the assessment, but as Janine said, make sure it's not just a tick box exercise. And one of the issues is that in cases such as this, it is easier to justify complying with a duty because the council in the end has no choice, rather than where you're using a power where the council's got a discretion. The threshold is going to be higher for when you're using a power in cases such as this. Okay, next slide, please. I'm now going to talk about something completely different. And this came out, our workshops I was doing a few years ago now, and I assume people were aware of it. And it became rapidly becoming clear that many councils were not, and to this day, it's probably still the case that quite a lot of councils are not complying with this particular legislation, and we'll come on to the implications of that in a moment. Now, those of you who understand the working in local governments will know that following the 2000 Local Government Act, effectively functions in local councils, with very few exceptions, were split into these executive and non-executive. And executive decisions taken by councillors, the cabinet structure, whether it's taken by a full cabinet or individual cabinet members, doesn't matter. Right from the start, decisions taken by councillors had to be recorded and published in a particular way. At that stage, it did not apply to such decisions taken by officers under delegated authority. So far, so good. Now, that applied to the whole of the UK. The Wales slightly later, slightly different legislation, but it applied to everybody. Since the 10th of September 2012 in England, and a bit later in Northern Ireland, but not in Wales, all executive decisions taken by officers under delegated powers also had to be recorded and published in the same way. Now, the catch is, if you're not immediately aware, the default position is that a council function is an executive one unless the relevant regulations say otherwise. There are some lists in the statutory instrument I referred to there, which say there are some things which can never be done by the executive and some things which are what's called local choice items, and that's up to the council to decide where they are. Well, ASB, Antisocial Behaviour Act stuff, is an executive function. Statutory nuisance is in the local choice list. That means you'll have to look at your constitution to find out who does it and who's responsible. Usually it's going to turn out to be the executive, but that's by no means always. However, even if you got off that hook, again in England, from the 6th of August 2014, non-executive decisions made under delegated powers, which also have to be recorded and published in the same way. That covers a lot of things, like including issuing licenses, permits, authorizations, all the rest of it. But particularly in this context, anything which affects an individual, well, taking antisocial behaviour action under whichever legislation in respect of an individual is something which is going to be covered by these regulations, even if it's not covered, by the previous ones. Next slide, please. So, what are the implications? Well, so what has to be recorded in the written statement as soon as reasonably practical? Well, the decision, who's taking it, when taken, the reasons for the decision, the options considered. So why are you choosing this power? Why aren't you following a particular duty? Why aren't you using other powers? Those sorts of things, and any conflicts of interest. Who has to do it? Well, the duty is very much on the decision maker. So if you're the delegated decision maker deciding to serve a particular notice or authorize a prosecution, you're in the frame. You have to make sure there is this written statement available. And how's it published? Well, it's supposed to be physically available as soon as reasonably practical. People are entitled to come in and ask for a copy. And it's also supposed to be published on your website as soon as reasonably practicable. Well, and the crucial question in the early years when I first stumbled on this is, well, does it matter? And I used to refer to that famous Clint Eastwood moment, do you feel lucky, punk? Had he fired 6 bullets or 5? And we didn't know. Now I suspect, unfortunately, we do, because there was a case in 2016 which dealt with an issue under the 2014 regs I've referred to, Cheshire and Westminster City Council, which indeed held that one of the grounds for holding that particular decision invalid was that it had not been recorded and published in the way required by the regulations. So, and this is the sort of $64,000 question, is, are you doing this for serving all your CPNs, injunctions, serving abatement notices, authorizing prosecutions, etc.? Because if you're not, what you're doing is handing an opportunity for the recipient to challenge that notice. And of course, if it's invalid, it's invalid from the word go. So it's important to do it. If you're not aware of these powers, go back and check with your democratic services or whoever, whatever it's called in your particular authority, and find out why your council isn't doing it. Because if you're the delegated decision maker, you have a responsibility. So quite an important issue. And if I was from the websites I've looked at, if I was advising the recipients of such notices, one of the first things I'd say is go and check whether it's been recorded or published. If it hasn't, you've got a line of attack which they may not have realised. Thanks, Huw. That's all I need to say.
Thanks, Tim. That's interesting. I think there'll be a couple of people who'll be rushing back to the office. Well, you won't be rushing back to the office, but checking on their websites or checking with their colleagues to make sure that they are discharging these responsibilities effectively and properly. If I can now pass over to Ian. Ian's is going to take us through some ASB tools utilising nuisance cases. Ian.
Thanks, Huw. Yes. Afternoon, everybody. Just wanted to talk this afternoon just very briefly about trying to make the use of the powers that are available to us, really. Next slide, please, John. Obviously, the ASB Crime and Policing Act rewrote a lot of the powers that we have relating to antisocial behaviour. I still think of it as being a relatively new act, although it's been around now for, what, 6 years. And possibly that's because there still seems to be either an ignorance or a lack of embracing some of the powers that the Act provides for us. And I think it's important that we look particularly at how we can utilise the powers that we've got, and particularly today. Next slide, John. If we can concentrate on, say, community protection notices just as one of the powers, just because it links in with statutory nuisance, which obviously is again a power that most authorities are familiar with. Now, I do quite a lot of statutory nuisance training, and when the Act first came into play, I introduced a couple of extra slides into my training pack about statutory nuisance that talked about CPNs, community protection notices, just because of that similarity. Now, obviously, when it was first introduced, the Act, and I used to ask people if they'd heard of CPNs, there was generally a look of puzzlement around the room. Very few people knew about them. And obviously, as time's passed, that situation has changed. Certainly, there are people now, less people are unfamiliar with the concept. A lot more people are utilising CPNs as part of their sort of normal practice. Having said that, still typically in a group of, say, 12, 15 people, there'll still be a couple of people who are looking a bit embarrassed, possibly that they don't know about them. But also I get people saying, well, we're not authorised. So yes, we know about them, but we don't use them because we've never been authorised to use them. Or no, that's the ASB team. It's not something that we do. It's another part of the council. Or I even get even more strange results, such as, the legal team don't like them, and therefore we don't use them for that reason. Or we don't really consider them to be part of the toolkit that we use. So, we don't use them for that reason. Now, other authorities, when you talk to them about CPNs, their eyes light up because it's become their principal weapon that they use for a whole host of different factors and issues. And in fact, looking at the stats, between 2014 and 18, so since they were introduced to 2018, there were 20,000 CPNs issued nationally, which far exceeds the numbers of abatement notices that are being issued, but interestingly, only served by 192 authorities, which is less than half the authorities that exist within England and Wales. In 2017-18, 3 local authorities were responsible for a third of all the CPNs issued. Interestingly, one was Durham, which was subject to the case that Tim's just talked about. The other 2 were Leeds City Council and London Borough of Waltham Forest. So they were responsible for roughly 2,000 of the 6,000 notices that were issued, CPNs issued in that particular year. Can I have the next slide, John? So why does that matter? Well, what I would say is, let's think about this from our service users. Service users come to us with a problem, and they want our help to solve that problem. They're not bothered about what the legislation says. They're not bothered whether or not we're using nuisance or ASB or planning or housing tenancy issues or whatever it might be. They're only interested in their problem being solved. They're also not bothered about whether or not we're an environmental health officer or a planning officer or an ASB officer or a housing officer. That's not their issue. Their issue is they've brought the council a problem and they would like us to be able to sort it. Often, even if we're a housing provider, they're still not making a distinction because the council used to do housing, so therefore from their perspective, we're all one body, even though we're often not one body with several bodies. Next slide, John. So our job is to solve their problem. Importantly, and I think we don't do this very well, probably the first thing that we need to do is to manage their expectations. What can we do? How do we go about doing that? What are we expecting them to do to assist that process? What sort of timescales are we talking about? And what sort of outcomes are we able to achieve? I don't think we're very good at setting that out. And in not setting that out right at the start, sometimes that leads them to have an unrealistic expectation about what we can achieve, and often can lead to disappointment when we don't achieve what they think we should be able to achieve. Clearly, things often take quite a long time, and they have to play their part in the process, irrespective of what tools we eventually use to resolve their particular issues. The other important thing, I think, from our perspective, is not for us to artificially erect barriers that will impact on our ability to successfully solve their problem. And I think sometimes public authorities are very good at doing that. So it's someone to watch out for. And on the next slide, please, John. So ultimately, in order to resolve their problem, we should have as full a toolbox as we're able to utilize, making sure that we're not artificially restricting our ability to actually get a resolution that works for them. And what I would say is those authorities that saying, well, we're not authorized or we don't consider it to be a tool that we should use, are in fact doing that. They're tying a hand behind the back and therefore limiting their ability to resolve the issue that's been brought towards us. If we can have a full toolbox of tools to use, then effectively it's a win for us because we get a resolution, and it's a win for the customer because they also get a resolution. Next slide, please, John. So thinking about community protection notices and statutory nuisance, why do I put them in together in a statutory nuisance slide? And as I say, it's because there are some similarities. There are also some important differences. So those that are familiar with statutory nuisance know that Section 79 of the Environmental Protection Act lists 11 categories of statutory nuisance, very distinct categories describing what amounts to the nuisance, what type of premises often that relates to, and is quite specific. If the activity that's being complained about falls under one of those 11 categories, then potentially nuisance can be used as a solution. If it doesn't, then nuisance isn't an option. When it comes to using CPNs, there are no categories. It's any behaviour. So there are no restrictions in relation to what CPN potentially can be used to address. As long as it's behaviour, then it falls within the ability to use it. Both CPNs and statutory nuisance require a degree of unreasonableness. Tim may well pick me up on this because there's been cases that talk about whether or not unreasonableness actually forms part of nuisance or not. But as a general principle, I think we would still say that we're looking for behaviour that we would say amounts to unreasonableness. With nuisance, we're looking for something that's either happened, is happened before and likely to happen again, or hasn't happened yet but was going to happen in the future. And generally with a nuisance, one-offs, it's quite difficult to make them fall under statutory nuisance. When it comes to CPNs, we're talking about behaviour which is persistent or continuing. So I think, again, there are similarities there between the two. The next issue is probably the fundamental difference. When we're talking about nuisance, we're talking about something which is prejudicial to health, and either a nuisance at common law as a private nuisance or a public nuisance. When we're talking about CPNs, we're talking about a detrimental effect to the quality of life in the locality. And if I think about that in terms of a legal hurdle to get over, I actually think the CPN hurdle is slightly lower than the statutory nuisance hurdle. I think it's easier to show detriment to the effect of the quality of life in a locality. Obviously with nuisance, again, it's a power available to local authorities. That power can be delegated to who they see fit. Interestingly, with CPNs, not only is it available to local authorities, it's available to others as well. Could I have the next slide, please, John? Because CPNs can be issued not only by the council, but by the police and PCSOs under the police's obviously remit, but also importantly, social landlords. Social landlords can apply to the council for effectively authorization to issue CPNs, and the council can consider and then approve a social landlord to be able to issue CPNs. Now, I don't think there are many social landlords that have applied for that power. I don't think there are many local authorities that necessarily have granted that power to to social landlords if they've even been asked. Now, again, to my mind, that seems strange, because obviously social landlords are dealing with their tenants all of the time. ASB undoubtedly is a tenancy management issue, often overlaps with tenancy issues for private individuals, and therefore not to have the power that would allow them to tackle and nip ASB issues in the bud as early as they can, to my mind, seems short-sighted. I would just say it was, again, a benefit to social landlords to have that power, and also as a win-win in terms of the local authority as well, in the fact that it's obviously a better use of resources. Next slide, please, John. The other one of the other benefits of CPNs is the fact of not only can you stop things, which is, I suppose, similar to an abatement notice, and to take steps or actions, but you can actually require with a CPN quite positive steps to be taken. So, for example, if you're dealing with somebody whose ASB is associated with drug misuse, then potentially you can ask them as part of a CPN to go on a drug rehabilitation program or course, which is not something that I think you would ever be able to use as an abatement notice for. So it's got a broader scheme that allows you to actually deal with both the negative aspects of ASB, but also to try and address some positive change that hopefully will result in a long-term improvement. Next slide, please, John. In terms of sort of remedies, again, outside of London for an abatement notice, our only option in most instances is to take somebody to court and prosecute them. Yes, we can potentially do works in default. Yes, we can potentially go in and seize items if it's, say, noise-making equipment. But our ultimate sanction is to take somebody to court. With a community protection notice, we have the advantage that fixed penalty notices are available to us. So if we're dealing with things which are low-level ASB, where a fixed penalty notice would be a suitable penalty, then we've got something that doesn't take up court time, effectively is an administrative decision on behalf of the agency that's issuing it, and we can address things as a short, sharp shock for people. Yes, ultimately, if people don't pay CPNs or continue to breach notices, we've got that option of going to court as a secondary option. But sometimes just the threat of a penalty or the issue of a penalty for £100 is going to be sufficient for some people to sit up and take notice. Next ones, please, John. So what I'm advocating really is don't artificially restrict ourselves. We've got powers available that we can use. Make sure that our toolbox is full and we're able to use all the powers that are available to us. If we're not using them, then my question would be, why aren't we? Last slide. John? Okay.
Thanks, Ian. That's that covered an area I think that need to be considered by local authority environmental health departments, because I am aware that some are using quite extent, as Ian said, some are using extensively the powers, others aren't using the ASB powers, and it's something they need to needs to be thought about. I'm looking at the time. We've got 2 minutes left. I will be using the chairman's prerogative and closing the session on time. That's the one function and responsibility I had today. Perhaps we can just look at very quickly. Is there one? We've got time for one question. Can you move on to the question? We have got a series of questions. This one could take us probably half an hour to deal with. So I'm not sure whether it's worth going through these. What we'll do, we'll put the questions onto the community's website and try and deal with them individually. One thing I will ask the presenters though, is there a theme or is there a particular point you'd want to emphasize and draw on from all the 3 presentations? Is there one key point you'd want to make? If we can start with Janine to begin with.
Gosh, I think the biggest thing for me is quite simply just to make sure that when we are sort of triaging and assessing reports when they first come in, that we just are really thinking about the impacts as well as the behaviour type.
Excellent, thank you. Tim?
Yeah, I mean, one of the things which Janine underlined for me is, of course, with nuisance, you're looking at an objective standard, not what the impact on that individual, but on an ordinary person. Whereas, of course, with the antisocial behaviour powers, you are looking at the impact on the actual people. And that seems to me a fertile area for how you might use the various powers together.
Yeah. Ian?
Don't look for reasons not to do stuff, look for reasons to do stuff.
Oh, I like it. You had time to think about that one. Fair play. I like it. Thank you, three of you. Really grateful for your presentations this afternoon. And for those who've dialed in, I hope you found them very interesting. I certainly did. Just a couple of housekeeping points. We mentioned the RHE Global Community sites. Please engage with these sites. It gives you the opportunity to ask questions of colleagues, to get feedback on particular issues that could be causing you concerns or might be problems in your area. We are hoping to record the webinar, and it will be made available on the RHE Global websites and platforms, so you can view it again and share it with your colleagues, or ask your colleagues to dial in and have a look at it. Also, we'd be grateful if you can give some feedback on how you think it's gone this afternoon, and also we'd welcome any thoughts on other subjects you'd particularly want us to cover, either on webinars or in training events, online training events, because I suspect online training is going to be the thing we're going to be doing for quite a few months to come. I don't think we'd be getting in the classroom or going to exhibitions or conferences anytime soon. No chance to trash the expense card and get all these lovely things that your local authority colleagues get. I shouldn't be saying things like that, but I think so. I think there is going to be more opportunity for online events. So please let us know what you think. Once again, thank you to the delegates. The contact details are at the bottom there about the RIAMS communities. They're on screen now. It gives good a bit of information about what the community sites can do. Thank you all for dialing in. Thank you to the presenters once more, and best of luck with the various lockdowns that are taking place around the country. My thoughts are with you all. Thank you.
Thanks.
Thanks.